Hannah Mackey on behalf of Mr. Howard.
Oh, the shoes match too.
My nails too. They all match.
Oh, I was gonna do that. No, God. Go ahead.
Please state your name for the record.
Don Howard.
Thank you, sir.
Your Honor, request an adjournment. We're waiting for discovery. Our office has not received any yet.
Discovery.
Yeah.
The adjournment, I believe that animal has been put through the discovery process. So.
July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Right. So all I have left is. Court does call the case of People versus Garrett.
Panagle, Your Honor.
Panagle, of course.
Assistant Public Defender Jay Bellinger on behalf of Mr. Panagle, who approaches. And Mr. Panagle, can you please state your name for the record?
Here, Panagle.
And Your Honor, while I can say that my client is not awaiting the rapture, he is awaiting a response as to.
He really didn't have to, but go ahead, sir.
He is awaiting a response as to 20 seconds recovery court. I just submitted him for that yesterday. I was informed by Ms. Sample that he will have an answer no later than the 24th, and at which time I imagine we'll have some sort of resolution going up. I'm hopeful.
So is the answer, you think, coming on the 24th?
I think that they meet on the 24th, so I believe it will be.
Okay. So what I'll do is I'll adjourn this out to July 31st.
Thank you so much.
At 9 a.m. bond will continue.
I'll have an answer for you by then.
Oh, she's using her big words, asking me if we're doing recalls. Apparently we are.
Thank you, Your Honor.
Thank you.
I got this.
We're doing all this. Are they ready? Do you know if they're ready? Or you just hand it? What?
I'm voting insurrections.
I won't call what I want.
Oh my.
I know. Court calls case People versus Tyler Redmond. Gail's ready. I'm just here.
Yeah, the Assistant Public Defender on behalf of Mr. Redmond, Your Honor. Mr. Redmond, state your name for the record.
Tyler Redmond.
Your Honor, we're still waiting for an assessment to be done from the Circuit Court Sobriety Court. At this point, I would ask the court to, we thought it was
the 22nd.
Yes. Yeah.
Sobriety Court.
Yeah. At this point, I'd ask the court to set an exam, and we'll continue to look into that option as well. I've talked to the assistant prosecutor, and I've told him that if there is an assessment done and we're in a position to waive or resolve, I'll certainly give him notice in ample time to call if any witnesses.
So he hasn't even been assessed.
No, Your Honor, we thought that was going to happen by the 26th, and I think they're a little bit behind.
So you want an exam instead of adjourning it to see if you can make that happen? I mean, either way, it doesn't matter to me. But.
If we have the exam, I can still do the assessment.
Let's set an exam, Judge, if the court's okay with that.
No, discovery is complete to your knowledge.
Yes, Judge, to my knowledge.
People have their witnesses available the 15th.
Yes, Your Honor.
Preliminary examination in person, July 15th, 2025, 9 a.m. That is before Judge Moore.
Assessment is also.
Yeah.
Okay.
Okay. All right.
Bond continue.
Thank you, Your Honor.
I'm sorry. Jeez. Get ready. No. Court calls case People versus Lakita Roberts.
Here, Richard McDuffie for the people.
What'd she do?
Mike Getty, Assistant Public Defender on behalf of Ms. Roberts, who's here to my right. Your Honor, state your name, Ms. Roberts.
Lakita Roberts.
Thank you.
Welcome.
Your Honor, I'd ask to set this matter for an exam.
For exam?
Yes.
All discoveries complete?
I have reviewed the file. Looks like it is, Judge.
I believe so. I do want to just confirm with Mr. Petty.
I'm happy to talk about a global resolution. I've spoke with Mr. Ward about that, as I was instructed to do, and he and I are going to continue talking, Judge.
People have their witnesses available this 15th.
I'll move first.
If I can be
Their
heard,
examination in person, July 15th, 2025, 9 a.m. That is before Judge Washington.
if I can be heard, I'm sorry, Judge.
Sure.
Thank you. Your Honor, Roberts has been in custody for several weeks. Excuse me, I had a frog in my throat. She does have a place to live. She lives locally. She would, I think, I'd ask the court to give her an opportunity to avail herself of using a scram tether to ensure that her appearance in court, as well as any testing or other monitoring provisions that the court would deem necessary to ensure her appearance. She does. I'd ask the court her bond is set at $25,000 in this matter. I'd ask the court she does have a couple other matters that are pending. She has the matter in circuit court that Mr. Ward and I have also discussed. I believe her bond is $50 in that matter. Her bond's $100, I think, in a 14B court, 14B district court case where I think it charges illegal entry. So I'd ask the court to consider reducing this bond to something that she may be able to post with or personal cognizance with any conditions that the court deems necessary to ensure her appearance.
Response.
Your Honor, I would object to any change of bond conditions right now. Ms. Roberts also had a domestic violence case pending. I understand it was a final settlement and may have been dismissed yesterday.
It was.
That was a newer case, however. Ms. Roberts, this case is a bit older. It looks like looking at the previous notes, there was a benchmark issue for $25,000 cash assurity for failure to report to court, as well as community corrections. I think a subsequent violation for community corrections as well. I'm concerned, obviously, about the substance use in this case. I don't think that, given her history of failure to appear and some new offenses in the interim and failures to appear on this case and other cases in circuit court, that we can trust Ms. Roberts to, on her own, comply with court orders and show up.
Your Honor, the DV case was dismissed yesterday in my note.
Does she have any other things pending at this point or no?
No, just this matter, the illegal entry case in 14B, and there's a circuit court case with a $50 bond, Judge. There is a whole
$50 bond in her circuit court?
yes.
That was just because she had a bond in something else.
Behind the scenes, detectives were piecing together a timeline so tight that even the smallest inconsistency could expose everything. And this moment, it was the first real slip.
Yes, that's my understanding. It's a very old case. It was bench warrant. I think for some reason I don't think the bench warrant ever got on lien because the jail didn't know about it until it was brought to their attention during the pendency of this case.
Granted. Defendant's bond is set at $5,000 personal recognizance bond. Defendant is to report over. We'll do new community corrections test. She's to report over for once a week testing.
Okay, thank you, Judge, and we'll work on the other bonds as well. But thank you.
Thank you, Your Honor.
Thank you. False case, People versus Timothy Stevens.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Stevens, Your Honor, who's standing here to my right.
Sir, your name?
Timothy Stevens.
Thank you.
Your Honor, at this time, we'd ask the court to set this matter for a preliminary examination. Ms. Tana and I have it, and I discuss it.
Everyone.
Ms. Tana and I have had an opportunity to discuss this matter, and we're going to set it for exam.
Discovery is complete.
Yes, Judge.
Board have their witnesses available the 15th.
I believe so, Your Honor.
All right. Preliminary examination in person, July 15th, 2025. 9 a.m. That's before Judge. Judge.
Thank you, Your Honor.
On continue.
15.
Court called case, People versus Leo Stringa.
And Alex Warren Green on behalf of Stringa. Can you state your name? Leo Stringa.
Thank you. Okay. I have before me two plea forms. It's going to be pleading to 2 counts of 2 different cases to retail fraud, second degree, the 1-year offense. On a successful plea to that charge, count one would be dismissed. There's also an indication that a case out of 1482, which is a retail fraud third degree, would be dismissed on a successful plea in these cases. That's all right, John.
And that's our full understanding, Your Honor. Mr. Stringa is asking the court to consider a no contest plea to both of those counts.
Do I have reports? It does say no contest plea. Yes, I do. I saw these reports. All right. All right. May I have him some more?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth self you got?
I do. Leo Stringa.
Sir, it is this court's understanding that you are going to be pleading to 2 charges of retail fraud in the second degree. Is that your understanding?
Yes, it is.
All right. Those are misdemeanors, punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. You understand what a no contest plea is?
Yes, my attorney's described it.
All right. 2 things about a no contest plea. I have to make sure that you understand it. First of all, it means that as to each of these cases, you have no desire or do not wish to contest these charges. You understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand also, sir, in one of your cases, the case ending in 5508, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. Okay. You understand that?
Yes.
Basis for the no contest, please.
Lack of recollection, Your Honor.
All right. Sir, to the charge, I'll start with the 15th District Court matter. To the charge of retail fraud, second degree, let me just give you an offense date. Having occurred on November 20th, 2024 in the city of Ann Arbor, how do you plead?
No contest, Your Honor.
To that same charge, having occurred on November 20th, 2024 at 3825 Carpenter Road, that being the Meyer and Pittsfield Township, how do you plead?
No contest as well.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
Yes, I have.
Any question regarding any of those rights?
No questions.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Actually, no, the probation that I was on I'm done with.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced?
No.
You're doing this voluntarily?
Yes, on my own accord.
And of your own free will?
That is as well.
The court has been provided and has reviewed University of Michigan Department of Public Safety and Security for their case number 24-903-06211, as well as Pittsfield Township Department of Public Safety report for their case number 24-19305. Any objection to the court having reviewed those reports?
None from the defense, Your Honor.
Okay. Based upon a review of those reports, the court would find that there's a sufficient factual basis to determine the defendant's guilt. Sir, you understand that if I accept your plea in this case, between the time of the acceptance of your plea and the time of sentencing, if there's misconduct committed by you as defined by the Michigan court rules, you would, 1, not be entitled to withdraw your plea, and 2, any resolution or evaluation regarding this case, the courts would not be bound by in terms of sentencing. You understand that, sir?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea?
None from the defense, Your Honor.
Has the court complied with the court rule in both of these matters?
And the defense is satisfied.
Court will accept the defendant's plea of no contest to count 2 in both cases. Count 1 is dismissed. In the 15th District Court matter, a pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in the 15th District Court matter will occur on July 29th, 2025 at what time? 9 a.m. before Judge Balvo. In the other matter, court does accept the defendant's no contest plea to count 2, count 1 being dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in that matter will be July 9th, 2025, 9 a.m. before me. Bond in each of these matters will continue. Thank you.
Thanks, Leo. Thank you, Your Honor.
Thank you, Your Honor. Court calls case People versus John Terry.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Terry. Mr. Terry, could you state your full name when you get up here?
John Martin Terry.
Thank you.
And Your Honor, I believe the court has received a plea form as well as a signed advice of rights form. Mr. Terry will be pleading to an added count 3 of controlled substance use, and counts 1 and 2 will be dismissed.
That is what the court has in front of us. Is that a correct statement? All right, let's have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
John Martin Terry.
Hey, sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance.
Yes, sir.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking a plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty?
I would, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding those rights?
None, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
None whatsoever, yes, sir.
Anybody threaten you or coerce you?
Not at all.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
I am guilty, sir.
On the date of August 9th, 2022, at the location of Prospect Road near Berkshire Drive in Superior Township, Washington County, State of Michigan, did you have heroin in your possession?
I did, sir.
Had you used it?
Yes, sir.
And did you know what you were using was indeed heroin?
Yes, sir.
Sir, I do have to advise you that if I accept your plea, if there is misconduct committed by you as defined by the Michigan court rules between the date of this plea and the time of your sentencing, any plea agreements and or evaluations the court would no longer be bound by. You would also not be eligible to set aside your plea. You understand that, sir?
Fully understand that, sir.
All right. Counsel, are there any other pleas, threats, or inducements that have caused this plea that have not been stated on the records?
No, Your Honor.
Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
July 15th, 2025, at 10 a.m.
July 15th, 2025, time 10 a.m. before Judge Barr.
Thank you, Your Honor. And may I address bond?
What would the case be if you didn't? Go ahead.
Your Honor, so we did discuss this last week. I would just ask you to